The Indian Judiciary. The Indian judiciary is the third most important organ of the government. Its main function is to protect our fundamental rights, interpret the law, and to protect the liberty of an individual. It is the foundation stone of the modern democracy. Importance of independent judiciary. Number 1. Independent judiciary ensures that the fundamental rights of the citizens are well protected. Number 2. Judiciary safeguards the federal nature of the Indian political system. Number 3. Independent judiciary acts as the custodian of our constitution. Number 4. It also advises the president or the governor of a state on matters relating to law. Number 5. In case any dispute arises between the center and the state due to division of powers, the judiciary interprets the constitution and settles the differences. Independence of judiciary. The judiciary, legislature, and executive are the three organs of the government. There are some provisions which make judiciary independent of any influence from the legislature or executive. The provisions which ensure the independence of judiciary are: Number 1. The Chief Justice and other judges of the Supreme Court and state high courts are appointed by the President of India. While appointing them, the President is free from personal favors or any personal bias. Number 2. Judges of the Supreme Court, High Courts, and their Chief Justices cannot be removed from office except by way of impeachment. Number 3. Their salaries and allowances cannot be reduced during their tenure except in the case of financial emergency. Number 4. After retirement, they cannot plead in any tribunal of India. The Supreme Court, situated in New Delhi, is the highest court or judicial authority in India. High courts of the states and all lower courts are subordinate to the Supreme Court. Structure and process of judiciary. There are 25 high courts for 28 states and 8 union territories. The Supreme Court, situated at New Delhi, is the apex judicial body. The Supreme Court. The Supreme Court of India is the highest law-making body in our country. At present, it has one Chief Justice and 25 other judges. Appointment of judges. The Chief Justice of the Supreme Court is appointed by the President of India on the advice of the outgoing Chief Justice and the Prime Minister. Sometimes the Chief Justice of a High Court is also consulted. The other judges are appointed by the President after consulting the Chief Justice of the Supreme Court. Qualifications for the Supreme Court judge. In order to become the judge of the Supreme Court, a candidate, number 1, should be a citizen of India. Number 2, must have an experience of working as an advocate for at least 10 years in a high court or should have served as a judge of high court for 5 years. Number 3, must be a distinguished jurist in the eyes of the President. Tenure. Once appointed, the judges of the Supreme Court retire at the age of 65. The Chief Justice of the Supreme Court and other judges can be removed from office through the process of impeachment. A judge may also resign from his post by writing to the President of India. The president can terminate a judge on the basis of proved misbehavior or incapacity. No judge of the Supreme Court has been terminated from the office through the process of impeachment till date. Salaries and other allowances. The judges of the Supreme Court are paid high salaries. Besides high salaries, they are also entitled to rent free accommodation and other allowances. Their salaries are charged from the consolidated fund and cannot be reduced, except during the years of financial emergency. The objective behind this is to prevent any type of corruption. Functions and powers of the Supreme Court. The Supreme Court of India has to perform specific functions within the jurisdiction as provided by the Constitution. The functions can be elaborated under the following heads. Number 1. Original jurisdiction. Under original jurisdiction, the Supreme Court deals with those cases which come directly under its jurisdiction. These cases may relate to A. Center state disputes, B. Disputes between various states, C. The cases involving the violation of fundamental rights. Number 2. Appellate jurisdiction. The Supreme Court is the apex court for jurisdiction in India. When someone is not satisfied with the decision of the High Court of a state, he or she may ask the Supreme Court to review the judgment. The Supreme Court may reconsider the case. This is called appellate jurisdiction of the Supreme Court. Number 3. Writ jurisdiction. The Supreme Court is the guardian of our fundamental rights. When someone feels that their fundamental rights are violated or they are deprived of their fundamental rights, they can directly file a petition in the Supreme Court for redressal. The Supreme Court then gives special orders in the form of a writ to get the fundamental rights implemented. Number 4. Advisory jurisdiction. In addition to the above functions, the Supreme Court sometimes has to perform advisory functions also. Sometimes the President of India can refer any matter of public importance to the court for its advice. However, the President is not bound to accept the advice or suggestions made by the Supreme Court. The High Court. The Constitution of India provides for the establishment of the High Court in each state. At the state level, it is the highest organ of judicial administration. There are 25 high courts in India for 28 states and 8 union territories. The High Court exercises its powers within the territorial jurisdiction of the state concerned. However, Parliament has been given the power of putting even more than one state under one High Court. For example, Punjab and Haryana have a common High Court at Chandigarh. Appointment of the judges of the High Court. Like the Supreme Court, High Courts also have one Chief Justice and other judges. The number of the judges of the High Court may vary from state to state. The Chief Justice of the High Court of a state is appointed by the President of India after consulting the Chief Justice of the Supreme Court and the Governor of that particular state. For the selection of other judges, the President may also consult the Chief Justice of the state concerned. Qualification for the High Court judge. In order to become the judge of a High Court, a candidate must: number 1, be a citizen of India. Number 2, have at least 10 years of experience as an advocate in the state. Number 3, be a well known writer in the field of law or a distinguished jurist. Tenure. The judges of the high courts remain in the office till the age of 62. They may resign from their office in writing. They can also be terminated from their office through the process of impeachment. Salaries and other allowances. The Chief Justice and the judges of the high courts are paid high salaries and other allowances fixed by the Parliament from time to time. They are also entitled to free accommodation. The President can transfer the judges of the high courts from one high court to another in consultation with the Chief Justice of India. Functions and powers of the High Court. The High Court deals with those cases which fall within the jurisdiction of a state. Some of the most important functions performed by a High Court are as follows. Number 1. Original jurisdiction. The Indian Constitution, under Article 226, empowers a High Court to issue a writ to any person or authority within its jurisdiction for the enforcement of fundamental rights or against their violation. It also hears directly the disputes related to state elections. Number 2. Appellate jurisdiction. The High Court hears appeals in both civil and criminal cases against the decisions of the subordinate courts, district courts, and reviews their judgment. The High Court has the power to give fresh verdict in such cases. Number 3. Advisory jurisdiction. According to Article 227 of the Indian Constitution, the High Court can extend its power of superintendence to all courts under its jurisdiction, except those dealing with armed forces operating under its territorial jurisdiction. Under Article 228, the High Court can also supervise the functioning of the subordinate courts. It enjoys the powers of judicial review like the Supreme Court. Subordinate courts. The courts at district level and below are termed as subordinate courts. The High Court is the highest court at state level, followed by the district courts at the district level. There are several levels of courts at the district level. The district court in a district also acts as sessions court. Revenue courts. Cases regarding payment, for example, collection of land revenue, property tax, or any kind of money, are dealt with by the revenue courts. Structure of a revenue court. The Board of Revenue is the apex revenue authority court at the state level. The Court of District Collector is at the district level. Below them are the courts of Tehsildar and Naib Tehsildar. Nyay Panchayats. A Nyay Panchayat provides justice at the village level. It can give its judgment on petty criminal and civil cases. Decisions taken by the Nyay Panchayat can be challenged in the higher courts. Lok Adalats. Lok Adalats was set up in India in 1985 for providing cheap and speedy justice to the poor. When it met for the first time in New Delhi, it solved 150 cases in a single day. Lok Adalats are also presided over by a retired judge and two other members as normal courts. The working procedure of the Lok Adalat is very simple. The parties involved in disputes may plead their case without advocates. These courts, adalats, provide quick justice by resolving cases in the court on the spot. The cases are resolved through mutual understanding. No appeal can be made against the decision of the Lok Adalat. Types of judicial cases. There are two types of judicial cases. These are A. Civil cases, B. Criminal cases. Civil cases. Civil cases are those cases which involve conflicts between people or institutions. These cases are concerned with private rights. Breaking of contract, divorce, and lawsuits are some examples of civil cases. In such cases, the claimant brings his claim against the defendant. The court settles the dispute in accordance with the law. Civil cases can also be solved outside the court. Criminal cases. Criminal offences are committed against the society. Robbery, murder, physical injury, and drunken driving are some examples of criminal offences. The court settles the cases relating to these offences. The court awards punishment to the guilty after a trial. The punishment ranges from petty fine to life imprisonment or even execution. The defendant is pronounced guilty or set free in accordance with law. Public interest litigation. Every citizen of India is supported to have an equal access to the courts. But in reality, it's not true. Poor people often do not have enough money for pursuing a case. The idea of going to a court to get justice often seems remote to a poor person who depends on daily wages. Because of poverty, the poor people of India rarely enjoy the fundamental rights provided to them by the Constitution of India. They are exploited both economically and socially. To sort out this problem, the Supreme Court of India has devised a mechanism known as Public Interest Litigation (PIL) to increase access to courts. In case of violation of their fundamental rights, citizens can directly appeal to the Supreme Court or high courts of their respective states. Due to large size of the country, the power to decide on issues relating to fundamental rights is given to the Supreme Court and High Courts both. If the fundamental rights are violated, these courts can immediately issue a writ for their enforcement. PIL may be filed in the Supreme Court or in the High Court by a group of people or an organization on behalf of those people whose fundamental rights are being violated. The PIL is only admitted by either Supreme Court or High Court when convinced that the case is for the public cause.